All right, guys. Thank you very, very much for agreeing to look through this slideshow for me for graduate school. Basically, what this presentation is about is different educational laws and policies that I feel like directly affect us as educators, general education or special education. It's just really good things to know as we navigate into, diverse students and really meeting the needs of kids and making sure that we're following law and policy and also looking out for our own self as well. So basically the reason that I think this is so important, why I chose you guys is, we talk a lot about the inclusion model and how we want kids to be in the general education classroom, whether that's from instructional pushed into gen ed or students that are already in gen ed. We want them, in the classroom as much as possible, kind of moving away from that pull out model into that inclusion model. I think with that comes a lot of stress, a lot of uncertainty, or even misunderstanding. So I think it's important to really talk about all of those things so that we don't have as much stress. We really understand clearly what's expected of us, and there's like no gray area. So I'm just going to go over 6 quick laws, something pertaining to least restrictive environment, which is so important for our SPED students, procedural safeguards, talking a lot about parents understanding their rights and how that affects us, the equal protection clause, talking about providing an equal education to kids and not engaging in discrimination, really understanding Senate Bill 100, which impacts us with student conduct very often. The New Jersey versus TLO case, which talks about students' Fourth Amendment rights and how the Fourth Amendment right is different in school than it is just in general. And then due process rights, us as teachers understanding our rights as we're navigating into new territory. We're co-teaching, we're working more with each other. We have collective efficacy, collective responsibility. We need to understand how that affects us as teachers. So the first thing we're talking about is least restrictive environment. Every SPED law really falls under that IDEA, Individuals with Disabilities Act, which was first implemented in 1975. It requires us to provide FAPE, that free and appropriate education. And free and appropriate education is the standard at which we look at things. So a student that's homebound, is that free and appropriate for them? Is a student that is in instructional, is that free and appropriate for them? What's free and appropriate for one student may not be what's free and appropriate for the other, but it's important that our end goal always be to be in the least restrictive environment, which is in their gen ed classroom, just with SPED support. A couple kind of jarring statistics that I found is that prior to 1970, 1 in 5 students with disabilities was actually provided an education. The other 4 were not. Children were actually denied access to education, and laws actually existed to exclude kids from school based on their disability. So what we're talking about, LRE, that least restrictive environment, ensures that students are educated to the greatest extent possible with their non-disabled peers. That is always the goal. That greatest extent possible is what we want. We know there's going to be different levels of achieving that based on a student's academic or social or behavioral needs. Really, it's the how and where special education services will be delivered. So our continuum of services that we hear a lot about in meetings that we don't talk enough about. Our most restrictive would be hospital or homebound. Alternative or special education schools. Those could be like therapeutic day schools, behavior-like schools, self-contained special education classrooms like we have here. And then the move toward LRE, that least restrictive would be special education provided in a general education classroom, which is really always the goal. So today, nearly 60% of students are educated with their non-disabled peers for up to 80% of their school day, which is great. I think the real breakdown comes when we talk about how do we support them in the classroom. I think I can't speak for a general education teacher because I'm not one, but I think oftentimes when we find out that we're going to have SPED kids in our class, we want to know what kind of supports we're going to be provided for them, and it can't all fall on the teacher, the general education teacher, to provide those things. So I think things that we need to think about are ensuring that those supplementary aids and services are in place. That's for all classes. That's part of those students' IEPs. That's things like it could be different executive functioning assistants, different manipulatives or graphic organizers that may benefit a student. We need to make sure that we as the special education staff are providing that in tandem with the general education teacher. It is on neither party on their own to get those things done. Accommodations and modifications to assignments and assessments. That's big. We need to make sure that if a student has a shortened test or eliminated answers, quality versus quantity, things like that are always in place on assignments and assessments. And again, that's done in collaboration between the gen ed and the regular ed, the gen ed and the SPED teacher. And then the biggest thing that would probably be the biggest help, which I know we're advocating towards moving towards, are those co-taught classes with a special education teacher in that classroom, along with the general education teacher, tandem teaching classes, pulling small groups within the classroom, providing strategies in real time for those special education students and the betterment of all of the students as well. So the second thing deals with procedural safeguards. This again falls under that umbrella of individuals with disabilities. This can also be called parents' rights and responsibilities, child and parent rights in special education. So this is super important. It's talking about parent and student rights. We need to make sure that we protect the rights of students with disabilities and their families. There are so many important things to procedural safeguards, but probably one that impacts teachers the most, and most specifically our special education teachers, is to remember that parents have a right to the students' records and can be informed of decisions made about their child. So when we talk about the special education law, there are things that a parent has. They can have due process if there are any conflicts, independent evaluations done, which we know some of our families do, a right to mediation, a right to have a voice if their student is being placed, if a placement decision is being made for their child, or in this case, we're talking about access to student records. It's so important that we recognize that parents can ask for our records whenever they want. I've been in teaching for 15 years, and while I have never actually had a parent ask me for my raw data, the data that I use to update goals or write goals or how I accommodate tests, et cetera, I've never experienced a parent asking for those things, but I am aware that that is a real possibility. We need to make sure that as, in tandem with the general education teacher, but this one falls more on the SPED teacher, that we maintain accurate grades, accurate IEP goals and objectives, formative and summative assessment data, and those standardized tests. It is so important that we have raw data to support how we're updating our IEP goals. Sometimes it's great, it's through AIMSweb, it's all there for us, but I have plenty of goals that are not assessed through AIMSweb. So I ensure that I have that data if a parent would ever ask. Of course, it's best practice. It's how we should be informing our teaching. It's also important that we cover ourselves and make sure that we're doing right by our students and right by ourselves. The next one talks about the Equal Protection Clause. This was instated in 1868. It was intended to eliminate discrimination of African-American students. Obviously, we know that there was Plessy versus Ferguson in 1896, where we agreed that separate but equal was appropriate. We had students of different races being educated in different schools. That was then overturned by the Brown Board of Education in 1954. In 1886, the Equal Protection Clause genuinely thought that Plessy versus Ferguson was okay. They felt like separate but equal was equal. So this law has changed a lot over time. It's important that we continue to change with those changes. Basically, this law talks about how now we cannot, back then it was just about race. Now we talk about we cannot discriminate based on race, sex, immigration status, sexual orientation, or mental or physical disability. The one that we, probably that we're impacted the most on is that mental or physical ability, making sure that we are providing that education to students regardless of that. And a lot of that I feel like does happen at a level higher than our classroom. We are just given certain students and we have the obligation to provide them an education. That's just something to be very mindful. Make sure that our students are getting the services that they are entitled to. Sometimes we're their greatest advocate. If they don't have a parent advocate that is loud and gets their kids what they need, it falls on us. We have to make sure that our students are getting their needs met. Senate Bill 100, this is part of Public Act 99046, and it was instituted in 2015. It basically outlines the zero tolerance policy for student suspensions. Before, sometimes there was a zero tolerance policy. If you fight, you're suspended. If you engage in certain activities, you are suspended. Prior to this law, we saw suspension rates just disproportionately increase for students of color, of low socioeconomic status, or students with disabilities. And we knew that something needed to be done because we can't just continue. Basically, that school suspensions became that school to prison pipeline, and they needed to do something to make sure we had some restorative practices in place. Now, it's not to say that suspensions cannot occur. It's just to say that things need to be in place before suspensions occur. We can't use suspension as the only form of discipline because it doesn't actually work. Taking a kid away from their education is not always going to teach them the skills that they need to be able to integrate into an education. So things that a student can be suspended for are some of the things that come into the Senate bill, as if there's gross misconduct or disobedience. So you need to make sure that we're documenting everything, even when things seem small, making sure that we're documenting so that when we do get to that gross misconduct or disobedience, we have the data to prove that it happened. We know that suspensions typically can last up to 10 days. We need to allow kids to be able to complete their work if they're suspended. We need to make sure that we're providing a lot of details of the incidents and if there's an allowance for a hearing. We always offer a hearing to parents or to families. So we need to make sure that we've done our due diligence and we have a lot of evidence. And then the big piece is that description of previous interventions used. As I said, we can't jump right to a suspension for the most part. There are definitely instances where it does happen a lot with like physical aggression and things like that. But we do need to make sure that we have a lot of previous interventions used. Luckily for us, the district does have a lot of things in place. Sorry, I got ahead of myself. Those would be things like making sure we're using Capturing Kids' Hearts, maybe making sure we're using PBIS, making sure we're using Safe Recess. Make sure you're using all those things with fidelity so that if it does come time to something that's suspension worthy, we can very definitely say, these are all the things we did that did not work. Now we need to address something else. The next one is New Jersey versus TLO. This was a case that took place in 1985. Basically, TLO was a 14-year-old female who was accused of smoking at school. After she was searched, she was implicated in a drug dealing scenario in school. And basically, the parents and the family argued that her Fourth Amendment right to search and seizure was not upheld at school. They didn't think there wasn't an indication that she was using drugs. There wasn't a warrant. There wasn't necessarily reasonable cause to search her. And basically, when we talk about the Fourth Amendment right in schools, it's a balance. We still need to make sure that students have their right under the Fourth Amendment because they are citizens. We also have this huge responsibility to maintain school safety and discipline. And I chose this one because I think it's so important. I felt like that recent case where that little boy had the gun at school and was able to shoot his teacher, there was a lot of like conversation of like, I didn't feel comfortable going in his backpack. There were teachers that said they maybe thought something was up, but no one felt comfortable going through this child's backpack. And it really got me thinking about like, how does that impact us at school every day? So in that case specifically, what the outcome was that the student surely had a right to privacy in private schools, but they are in school, you are afforded a lower standard of protection than is usually given. Yes, you have rights, but once you come into a school, that right is significantly lessened. So they weighed on the side of maintaining school safety and discipline. Something that I did not know I was given information from my mentor, Beth Reich, the principal at Serena Hills, is that actually written in our board policies, and I did look this up more, Dr. Smith basically has said that if you're at school, your right to privacy essentially doesn't exist anymore. If a teacher has a suspicion that there's something in your backpack or there's something going on, they have a right to investigate that. So if something seems off to you, if a backpack seems off to you, we have the ability to search those things. Because if you're on school property, your property is now school property. That's just something super important to remember as behaviors tend to escalate and we're seeing students with like much more complex needs. We do have that ability to search out things that don't seem right to us. The last thing that I want to talk about is due process rights for our teachers. We are moving into like for some of us, uncharted territory. Some of us have worked in education for a long time, some of us for less time. This idea of moving into the least restrictive environment may be different for a gen ed teacher who hasn't always had, an influx of special education students in their room. Or even for me, I've always worked in a therapeutic day school where kids were pulled out and we were in a separate school. And even now, some of my work is done in my small classroom. There is this gigantic push to make sure that to the greatest extent possible, we are getting these kids into the general education classroom. With that, our job roles change a little bit and our expectations change a little bit. So how we're evaluated, still with the same tool, but we may be doing different things and being evaluated on different things now that our roles are changing. So I think it's super important to know your rights. If you're a 10-year teacher or nearing tenure, it's very important to know that when you do get your evaluations, you can and are encouraged to uphold your rights to due process. If you're accused of something or being let go, you have the right to know why, and you have a formal opportunity to challenge that dismissal. It's extremely important to know that. It's extremely important to know our rights and that we do have a right to, show what we've done, show our side of things. So it also goes back to making sure that we maintain really good records, make sure that we're covering ourselves in every way, shape, or form so that if something like this were to happen, we would have a lot of data to support why we made the decisions that we did, what we've brought to the table. So I know that was a ton of information. These were just some references. I'm also going to send an email with just a quick survey. It's like 4 questions that are open-ended, just asking what you thought about the presentation. If you could just fill that out for me, I would be hugely appreciative. Thanks, guys.